Let's talk about a case decided a couple of weeks ago, Andrus versus Texas. This is astonishing. This is astonishing to me, this case, the way they ruled this. Explain the situation. It deals with the Sixth Amendment.
Yes. So the Sixth Amendment guarantees a right to effective assistance of counsel, meaning that if you get a lawyer who does an absolutely atrocious job, you can have your verdict, your conviction overturned and get a new trial. And this case involved a terrible lawyer who did an atrocious job. His client was on trial for 2 murders in Texas. It was a capital trial. And the whole deal at capital trials is that the defendant has to present what's called mitigating evidence to show that they don't deserve the death penalty. And if a single juror, in Texas specifically, decides that the mitigating evidence is strong, then that individual cannot be executed or subject to the death penalty. And this lawyer did not present any mitigating evidence for his client, Mr. Andrus, even though his client had been horrifically abused from an extremely young age, tormented and tortured by his mother's many boyfriends, exposed to horrific domestic abuse and drug use, placed in a notoriously cruel juvenile detention center where he was overdosed with psychotropic drugs to treat severe mental disorders that are exactly what led to him committing this crime. So, this was so obviously ineffective assistance of counsel for the lawyer not even to say this, to keep the jury in the dark, that in 2020, the Supreme Court issued a decision that said, as a matter of constitutional law, what this guy's lawyer did violated the Sixth Amendment. This is not effective assistance of counsel, and sent the case back down to the Texas Court of Criminal Appeals to apply the Sixth Amendment correctly. And incredibly, the Texas court said, actually, we disagree with the Supreme Court. We think that the Supreme Court got it wrong. We don't believe that this was ineffective assistance of counsel, and we are not going to overturn this guy's conviction, which is just open and direct defiance of SCOTUS. And so Mr. Andrus appeals this decision back to the Supreme Court, and the court swats it away and refuses to consider it, and effectively allows a lower court to overrule it from below, which is just not how precedent or stare decisis works.
And so what are the implications, though, in terms of the way that it affects the law going forward?
I mean, what it means is that a conservative majority of this Supreme Court doesn't care about protecting the right to counsel and the right to effective assistance of counsel. And that's a huge problem because so many cases involving the death penalty involve ineffective counsel. As a general rule, if you have a good lawyer, you will not be sentenced to death. Good lawyers can generally avoid a death sentence. It's only ineffective lawyers in all but the most extreme cases who can't figure out how to avoid it. And so all of these people on death row, they are trying to bring these claims to show that their lawyers, in some cases, literally fell asleep during the trial, failed to do any investigation to puncture the prosecution's evidence, didn't even cross-examine key witnesses, that kind of thing. And over again, the Supreme Court has been shutting down those cases and using both procedural and substantive tools to do it. So just a few weeks ago, the conservative supermajority, basically slammed the courthouse door shut on people who received ineffective assistance of counsel and were sentenced to death, even if they have compelling proof that they are literally actually innocent and that they could not have committed their crime because they have a watertight alibi. The Supreme Court 2 weeks ago said, we don't care. You do not get access to a court. You are going to be put to death without ever presenting your claim. And this latest decision follows on the heels of that and is very similar.
So just to be clear, there's 2 different cases that we're talking about that deal with the Sixth Amendment over the past month, essentially. One is the first one, not the Andrus case. The first one was ineffective counsel. Then they had ineffective counsel in arguing that they had ineffective counsel. And once you get one case removed from the first ineffective counsel, the Supreme Court says, okay, all bets are off. This right expires on some level or something.
That's absolutely right. The court has put an expiration date on constitutional rights that it disfavors. And it has really just shut down what's called habeas review, which is what you get when you've already been convicted of a crime, but you have, say, new evidence or the law has changed. You have some reason to say that your conviction was unlawful and illegitimate. The court has basically quashed that and said that it's not available anymore because Anthony Kennedy is gone and things have changed around here.
Yeah, and this is less of a legal question and more of a political one, or maybe not, but it should go without saying, right, that the ineffective counsel cases are probably disproportionately in representation of poor individuals who have less access to good lawyers. I mean, almost exclusively. Near 100%, right?
Yes. Again, it's this problem of if they had good lawyers in the first place, they wouldn't be in this situation. The death rows of various states are filled with people who had bad public defenders who were representing 50 clients at the same time, who had 10 minutes to prepare for a capital trial. And the Supreme Court has basically blessed that system because I think, frankly, a conservative majority doesn't even believe that there is a right to effective assistance of counsel. But the court has realized that it can avoid backlash by not just saying, okay, well, there's no more right here. They just cut off all access to exercising that right. So lower courts can just deny Sixth Amendment claims and we won't do anything about it. Federal courts can slam their doors to new evidence and we won't do anything about it. It's this concept of not overtly reversing precedent, but allowing it to die on the vine. And that is a political strategy as much as a legal one that this conservative majority has very much embraced.
I want to just focus on that dynamic for a moment because, the mistake I think some people make about the Supreme Court is they will look at a case and they'll look at the specifics of that case and assume that the case begins and ends with that. But that's not the way it works with the Supreme Court. The Supreme Court is creating a structure and a superstructure for the rest of the courts in the country. And in this instance, it's a state court, which is in some respects theoretically outside of its its branch of government slightly, because this is a state court as opposed to the federal court system. Can we even imagine what the implications are of this? Sometimes it's very hard to, when they did Bush v. Gore, they said this case is it. This is a one-off. This has no bearing on future cases. We don't even want you to cite this case. And I don't know how many times that Bush v. Gore has been cited, but I know it's like at least dozens of times in federal cases since then. Correct me if I'm wrong on that. But do we have a sense of what message this sends to Supreme Court justices, state Supreme Court justices in South Carolina, Missouri, Alabama, or what it says to even to circuit courts, maybe in the Fifth Circuit that deals with some of these, these red states, conservative justices on there. Can we even project into the future what the implications of this are?
You took the words right out of my mouth with the Fifth Circuit. Obviously, what's going to happen is that conservative and partisan lower court judges are going to start ignoring decisions of the Supreme Court that they dislike and hope that they can get away with it. And I think you described it very well. Another way to think about it is that the Supreme Court sits at the head of a massive bureaucracy. We don't think of it that way because it's judicial, but it is just another government bureaucracy. And the lower courts, state Supreme Courts, federal appellate courts, they are sort of like middle managers, and they take their cues from the top. And they are really good at reading those cues, whether they are loud and blaring or subtle. And what the court is telling them now, all of these middle managers on the courts below, is, hey, you can pretty much guess which constitutional rights we don't like and which precedents we want to overturn. And if you just stop enforcing them, if you just start violating our precedents, we're not going to do anything about it. In fact, we might even give you a pat on the head. And so this goes way beyond the Sixth Amendment context. I mean, I think this case is tragic and horrific, but it's so much more than the right to counsel. This was the game that the Supreme Court played with abortion, and it's the reason why abortion is already illegal in 2 states, even though Roe is still on the books. Now they're playing it with the right to counsel. What will be next? And so it's a way for the court up at the top to kind of protect its reputation. This is an extreme example, but there was this idea in Germany of working toward the Führer. The Führer didn't say exactly what he wanted, but his people knew the idea and worked toward it. That is what the Supreme Court is doing with lower courts. They're saying, work toward us. Figure out what we want and do it, and we will reward you when you do it correctly, or at the very least not punish you.
It reminds me of that the Wells Fargo scandal, where they had basically said, like, you're going to get bonuses if you sign our clients up for these other things.
Open more accounts.
Open more accounts and whatnot, and just get it done. And then you had, Wells Fargo underlings signing people up for these, extra products that they didn't even know that they were signing up for. And that was just sort of, and then they're just like, whoa, we had no idea. We just created the circumstance. It's not too dissimilar from the torture regime, frankly, on some level, where the Rumsfeld basically said, we're unshackling you guys. You guys go at it, and you'll be doing God's work. We're not going to give you the order to do that. And just you referenced abortion, just so that people know what you're talking about. That Texas case never was resolved. They just basically punted it. And by any stretch of any imagination, it was a de facto overturning of Roe v. Wade. I mean, by any measure whatsoever, it encumbered a woman's right to choose prior to whatever it was, 24 weeks of gestation.